The billing alert arrived at 2:17 a.m. on a Tuesday, flagging invoices I'd never reviewed. I'm Ethan Donovan, 42 years old, a non-equity partner specializing in corporate litigation at one of Dallas's most prestigious partnerships. 20 years of practice had taught me to trust my instincts, and something about that automated notification felt wrong. The email sat in my inbox like a digital landmine. Billing discrepancy alert. Invoice 47,291. Client matter 2024, CLO 847. I'd been handling 3 major merger disputes that month, burning through 18-hour days preparing for depositions. Sleep had become a luxury I couldn't afford. But I'd never seen that invoice number before. I pulled up our case management system from my home office, fingers moving across the keyboard with practiced efficiency. The invoice appeared on screen. $47,500 in legal fees for client consultation services. My electronic signature sat at the bottom, crisp and official. The problem was simple. I hadn't signed it. The timestamp showed the document was created last Thursday at 11:43 p.m. I'd been in Houston that entire week, taking depositions for the Meridian Industries case. My laptop had never left the hotel room, and I'd logged every billable hour meticulously. I scrolled through the invoice details. The work description was generic: strategic legal consultation and case analysis. No specifics, no time entries, no supporting documentation, just my signature, perfectly replicated, authorizing nearly $50,000 in fees. My hands went cold. I accessed the firm's digital signature logs, a security feature implemented 6 months ago after a minor billing dispute with a client. Every electronic signature was supposed to generate an audit trail showing the user's login credentials, IP address, and device information. The log entry for my signature showed an anomaly. The IP address traced back to our firm's internal network, but the device ID belonged to a computer I'd never used. Someone had accessed my signature from inside the building while I was 300 miles away. I pulled up 3 more invoices from the past month. Same pattern. Same generic descriptions. Same impossible timestamps. My signature appeared on documents totaling $127,000 in fees for work I'd never performed. The billing system showed these invoices had been sent to clients and marked as paid. The money had already been processed through our firm's trust account. Someone was using my identity to steal from our clients, and they had inside access to do it. The discovery hit me like a cold slap at 2:17 a.m. on a Tuesday. I'd been working late cases for 15 years, but this felt different. Personal. I am Ethan Donovan, 42 years old, non-equity partner specializing in corporate litigation at one of Dallas's most prestigious partnerships. We handle Fortune 500 companies, complex mergers, and high-stakes commercial disputes. Trust is everything in this business. The fraudulent invoices weren't random. Someone had studied my billing patterns, my client relationships, my signature style. They knew exactly when I'd be out of town, when my attention would be divided across multiple cases. I started with the obvious suspects. Our billing department had 3 people with administrative access to the invoice system. I pulled their login records for the past 6 months, cross-referencing them with the fraudulent document timestamps. Nothing matched. The IT department maintained detailed access logs for our case management software. I requested the records under the pretense of investigating a potential security breach. The logs showed normal activity patterns for all authorized users during the relevant time periods. But one name appeared consistently during late-night hours when the building should have been empty: Gregory Carrington, our firm's compliance advisor. Gregory had joined us 18 months ago with impeccable credentials. Harvard Law, 10 years at a white shoe firm in Manhattan, specialized expertise in legal ethics and regulatory compliance. The partners had recruited him specifically to strengthen our internal controls after a minor audit finding the previous year. We'd worked together on several compliance initiatives. He'd helped design our new billing protocols, implemented enhanced security measures for client trust accounts, and established the digital signature system that had ironically exposed his fraud. I remembered our conversations about firm finances during late-night strategy sessions. We'd discussed client billing practices, trust account management, and the importance of maintaining ethical standards. He'd seemed genuinely committed to protecting the firm's reputation. We created our firm's compensation model together, spending weeks analyzing partner contributions and developing fair distribution formulas. Gregory had insisted on transparency, arguing that hidden compensation arrangements bred suspicion and undermined firm culture. The irony wasn't lost on me. I needed concrete before making accusations. Corporate law had taught me to build airtight cases before filing motions. This situation demanded the same methodical approach. I accessed the firm's security camera system using my partner-level credentials. The cameras covered all common areas, including the corridor leading to the compliance office. I pulled footage from the nights when fraudulent invoices were created. There he was. Gregory entering the building at 11:15 p.m. on the night my signature appeared on the $47,500 invoice. The timestamp matched perfectly with the document creation time. He stayed for 47 minutes, long enough to generate multiple invoices and process them through our billing system. The pattern repeated across 6 different nights over 3 months. Gregory would arrive late, spend 30 to 60 minutes in his office, then leave. The next morning, new invoices bearing my forged signature would appear in client accounts. I pulled his personnel file. His background check had been thorough, but I noticed something troubling. His previous firm had dissolved 6 months before he joined us. The dissolution had been attributed to strategic restructuring, but no details were provided. A quick search of legal databases revealed the truth. Gregory's former firm had faced disciplinary action from the New York State Bar for trust account violations. 3 partners had been sanctioned for misappropriating client funds. Gregory hadn't been named in the proceedings, but the timing of his departure suggested he'd left before the investigation concluded. The curry Hepson was mounting, but I needed to understand the full scope of his operation. I analyzed every invoice bearing my signature over the past year, looking for patterns and anomalies. The results were staggering. Gregory had generated 43 fraudulent invoices totaling $892,000 in false billings. The money had been processed through legitimate client accounts, making the theft nearly invisible to routine audits. But where had the money gone? Our firm's trust account showed proper distributions to partners based on the inflated billing numbers. Gregory's compensation had increased accordingly, but not enough to account for the full amount. I accessed the detailed trust account records, following the money trail through multiple transactions. The pattern became clear. Gregory had been skimming funds during the distribution process, redirecting portions of client payments to a separate account before they reached the main trust fund. He'd stolen $347,000 over 18 months, using my reputation and signature to legitimize the theft. The remaining funds had been distributed to partners as normal compensation, making us unwitting accomplices in his scheme. The sophistication was impressive. Gregory had exploited his position as compliance advisor to modify internal controls, creating blind spots in our audit procedures. He'd used his access to client information to target accounts with complex billing arrangements where additional charges might go unnoticed. Most disturbing was his psychological manipulation. He'd positioned himself as the firm's ethical guardian, while systematically stealing from the clients he was supposed to protect. Every compliance meeting, every discussion about professional responsibility had been an elaborate performance. I printed and secured it in my office safe. The documentation filled a 3-inch binder. Invoice copies, access logs, security footage timestamps, trust account records, and financial analysis showing the money trail. But I needed one final piece of logs. I wanted to catch Gregory in the money trail, to eliminate any possibility of denial or misdirection. I set up a monitoring system on my computer, configuring alerts to notify me whenever my digital signature was accessed. Then, I waited. The alert came 3 days later at 1:23 a.m. Someone was using my signature to create a new invoice. I drove to the office, parking 2 blocks away to avoid detection. The building was dark except for a single light in the compliance office. I used my keycard to enter through the side entrance, moving quietly through the corridors. Gregory sat at his desk, completely focused on his computer screen. Multiple windows were open: our billing system, client account records, and a document showing my forged signature being applied to a $23,000 invoice for emergency legal consultation services. I watched him work for 10 minutes, documenting his process with my phone's camera. He was methodical, professional, treating the theft like any other administrative task. When he finished and prepared to leave, I stepped into the hallway. "Working late, Gregory?" He froze, laptop bag halfway to his shoulder. For a moment, his mask slipped, and I saw something cold and calculating in his eyes. "Ethan, I didn't expect anyone else to be here." I could say the same thing. "Especially since you just used my signature to bill a client for work I didn't perform." The silence stretched between us. Gregory's mind was racing, searching for an explanation that might salvage the situation. "I think there's been a misunderstanding," he said finally. "The only misunderstanding was trusting you with our firm's compliance program." "I know about all of it, Gregory. 43 fraudulent invoices. $892,000 in false billings. $347,000 stolen from client trust accounts." His shoulders sagged slightly. The performance was over. "How long have you known?" "Long enough to build a case that would make our litigation department proud. The question now is whether you want to handle this quietly, or wait for the authorities to get involved." Gregory set down his laptop bag and returned to his chair. When he looked up, the compliance advisor persona had vanished completely. "You have no idea what it's like," he said. "Watching partners take home seven-figure distributions while staff attorneys struggle to pay student loans. The system is rigged, Ethan. I just leveled the playing field." "By stealing from clients who trusted us with their legal matters?" "By taking what I deserved. Do you know how much revenue I generated through compliance improvements? How much money I saved this firm through better procedures? My compensation didn't reflect my actual contribution. The rationalization was textbook. I'd seen it in dozens of corporate fraud cases. The perpetrator always believed they were the real victim. We'll discuss your contributions with the managing partners tomorrow morning, along with the of your theft and the criminal charges you'll be facing." Gregory's expression hardened. "You're making a mistake, Ethan. This firm has bigger problems than a few billing irregularities. If you push this, you might not like what else comes to light." The threat hung in the air between us, but I'd come too far to back down now. "We'll see about that. Security will escort you out. Don't come back." I called building security and waited until Gregory was removed from the premises. Then I returned to my office and began preparing for the most difficult conversation of my legal career. The managing partners would need to know everything. Our clients would demand explanations. The state bar would launch an investigation. And somewhere in the chaos, we'd have to rebuild the trust that Gregory Carrington had systematically destroyed. But first, I had a criminal case to build. The emergency partners meeting convened at 7 the next morning. I'd spent the night organizing files and preparing for the inevitable questions about firm liability. Managing partner Valentina Carrington entered the conference room with the measured stride of someone accustomed to crisis management. Behind her came 3 senior partners, each carrying tablets loaded with the preliminary I'd distributed. "Walk us through it again," Valentina said, settling into her chair. "From the beginning." I opened my laptop and projected the billing analysis onto the conference room screen. Gregory accessed our case management system using administrative privileges. He copied my electronic signature and applied it to invoices I never reviewed. "The pattern spans 14 months, senior partner Gregory Whitmore leaned. "What's the total exposure?" $437,000 in fraudulent billings across 23 client matters. The signature analysis confirms the electronic manipulation. The room fell silent. Valentina made notes on her legal pad while the other partners studied their tablets. Client notification protocol? Asked partner Gregory Morrison. I've drafted disclosure letters for each affected client. We'll need to discuss full restitution and potential fee waivers for ongoing matters. Valentina looked up from her notes. Bar notification requirements? Mandatory reporting within 30 days. I've already contacted our malpractice carrier and prepared the initial disciplinary complaint. The questions continued for another hour. Each partner understood the implications. Client lawsuits. Regulatory scrutiny. Potential criminal charges. The firm's reputation hung in the balance. What about Gregory's threat last night? Valentina asked. His suggestion that other problems exist? I've found no of additional misconduct. But we should conduct a comprehensive audit of all financial systems. The partners exchanged glances. In 20 years of practice, I had learned to read these silent communications. They were calculating damage control strategies. Ethan, you'll coordinate with law enforcement, Valentina decided. We need this handled properly from a criminal perspective. 2 hours later, I sat across from Detective Gregory Patterson at Dallas Police Headquarters. The white-collar crimes unit occupied a surprisingly modern floor with glass-walled conference rooms and digital displays. Electronic signature fraud is becoming more sophisticated, Detective Patterson explained, reviewing my files. Your documentation is thorough. We'll need the original server logs and any backup systems. Our IT department has preserved everything. No data has been altered since discovery. Good. We'll coordinate with the district attorney's office for formal charges. This level of systematic fraud typically results in felony prosecution. The investigation moved quickly. Within a week, Gregory Carrington was arrested at his apartment and charged with theft, computer fraud, and professional misconduct. The local legal newspaper covered the story with the restrained tone reserved for attorney discipline cases. Client meetings proved more challenging than criminal proceedings. I spent 3 days explaining the situation to affected clients, offering full restitution and fee adjustments. Most accepted our response professionally. 2 clients terminated their relationships immediately. 1 threatened litigation. The state bar investigation began simultaneously. Bar counsel Valentina Sterling requested complete case files, financial records, and detailed timelines of Gregory's access to firm systems. Her questions focused on our oversight procedures and internal controls. How did Mr. Carrington obtain administrative access to signature systems? She asked during my formal interview. His compliance role required broad system access for audit purposes. We've since implemented dual authorization requirements for all signature applications. Were there any prior indicators of financial irregularities? None that triggered our existing monitoring systems. His billing patterns appeared consistent with legitimate compliance work. The bar's investigation lasted 6 weeks. Their final report recommended enhanced financial controls and mandatory third-party auditing for firms handling significant client funds. Gregory's law license was suspended pending criminal trial. The Client Compensation Fraud Investigation Bureau assigned white-collar case coordinator Jonah Friedman to oversee the restitution process. His office specialized in attorney misconduct cases involving client funds. Your firm's cooperation has been exemplary, Coordinator Friedman noted during our final meeting. Full client restitution within 60 days demonstrates genuine commitment to remediation. We take our fiduciary responsibilities seriously. This breach violated everything we stand for as a profession. Unfortunately, electronic signature fraud is increasing. Your case will help us develop better detection protocols for other firms. The criminal trial proceeded efficiently. Gregory's defense attorney argued diminished capacity due to financial stress, but the FIA was overwhelming. Electronic logs, signature analysis, and client testimony painted a clear picture of systematic fraud. The jury deliberated for less than 4 hours, guilty on all counts. Judge Gregory Hamilton sentenced Gregory to 18 months in state prison, followed by 3 years of supervised probation. Full restitution was ordered, though Gregory's assets covered less than half the stolen amount. "Mr. Carrington," Judge Hamilton said during sentencing, "you violated the most fundamental trust between attorney and client. Your actions damage the entire legal profession. Our firm covered the remaining restitution through our malpractice insurance and operating reserves. The financial impact was significant but manageable. The reputational damage proved harder to quantify." 3 months after Gregory's conviction, I received a call from another Dallas firm. Their compliance officer had discovered similar signature irregularities in their billing system. "We heard about your case," the managing partner explained. "Could you consult on our investigation?" I agreed to help. The pattern was identical to Gregory's methods: electronic signature manipulation, systematic billing fraud, administrative access abuse. Working with their internal team, we uncovered 8 months of fraudulent activity totaling $200,000. Their compliance officer had learned Gregory's techniques during a professional conference they'd both attended. The second case resolved more quickly. Our experience provided a roadmap for collection, client notification, and regulatory compliance. The perpetrator accepted a plea agreement and surrendered his law license voluntarily. By years, I'd consulted on 4 similar cases across Texas. Each investigation revealed the same electronic signature fraud pattern. The technique was spreading through professional networks and continuing education programs. The State Bar responded by implementing new requirements for electronic signature security and mandatory fraud detection training. Our firm became a model for compliance procedures and internal controls. Valentina Carrington approached me in December with an unexpected proposal. "The partners have been discussing your role in this investigation," she said. "We'd like you to head our new financial compliance division. Full equity partnership. Specialized focus on preventing and detecting attorney misconduct." The offer was generous. Equity partnership represented the pinnacle of law firm achievement. But something about staying felt wrong. "I appreciate the confidence," I replied, "but I think it's time for a change." 6 months later, I opened my own practice in a renovated warehouse in Deep Ellum. The exposed brick walls and industrial lighting felt honest after years in corporate towers. My client base grew through referrals from attorneys who'd heard about the Gregory Carrington case. The practice focused on legal ethics consulting and financial compliance auditing. Law firms across Texas hired me to review their billing systems, implement fraud detection protocols, and train staff on electronic signature security. My first major client was a Houston firm with 300 attorneys. Their managing partner had read about our case in the Texas Bar Journal. During the initial consultation, I discovered vulnerabilities in their document management system that could enable signature fraud within hours. "How many firms have these same weaknesses?" the managing partner asked. "Most of them," I replied. The Houston engagement led to a statewide contract with the Texas Association of Defense Counsel. I developed standardized compliance protocols that member firms could implement regardless of size or practice area. The program included quarterly audits, staff training modules, and incident response procedures. By winter, my practice employed 4 attorneys and 2 forensic accountants. We'd audited 67 law firms and identified fraud attempts in 12 cases. The patterns remained consistent: administrative access abuse, electronic signature manipulation, and systematic billing irregularities. The State Bar adopted our audit protocols as recommended best practices. Bar publications featured articles about electronic signature security and internal fraud prevention. The continuing education requirements now included mandatory compliance training based on our case studies. Valentina Carrington called in February to update me on the firm's progress. They'd implemented comprehensive financial controls and hired a dedicated compliance team. Client trust had largely recovered. The partnership was stronger than before the crisis. "Gregory's actions forced us to examine everything," she said. "The new systems are bulletproof." I'd heard similar statements from other firms. The Gregory Carrington case had become a cautionary tale that prompted industry-wide reforms. Electronic signature fraud was now a recognized threat with established countermeasures. The Client Compensation Fraud Investigation Bureau published a comprehensive report on attorney billing fraud that cited our case as a model investigation. Jonah Friedman's team had processed 43 similar cases in the past year, all following patterns we'd first documented. In March, I testified before a state legislative committee reviewing attorney regulation statutes. The committee was considering new requirements for law firm financial auditing and electronic signature verification. The current system relies on self-reporting and reactive enforcement, I told the committee. We need proactive measures that prevent fraud before it occurs. I advocate for mandatory third-party auditing of firm finances. The proposal faced resistance from larger firms concerned about costs and confidentiality. But smaller practices supported the measure as protection against internal threats they couldn't detect independently. The legislation passed in modified form. Beginning next year, all Texas law firms must undergo annual financial audits conducted by certified public accountants with legal industry experience. The audits will include electronic signature verification and billing system security reviews. My practice had evolved beyond consulting into advocacy for systemic reform. The work felt meaningful in ways that traditional legal practice never had. Each audit prevented potential fraud. Every training session protected clients and attorneys alike. On a quiet Friday evening in April, I walked through my office reviewing the week's accomplishments. 3 firms had implemented new compliance protocols. 2 potential fraud cases had been prevented through early detection. The legislative committee had scheduled hearings on expanded audit requirements. The city lights sparkled beyond my windows. Dallas continued its relentless growth, but the legal community was more vigilant now. The Gregory Carrington case had changed how attorneys viewed internal security and professional responsibility. My phone remained silent. No emergency calls about discovered fraud or compromised billing systems. The compliance protocols were working. The industry was adapting. It was finally over, and the silence felt earned.